Chief Standing Bear is in a unique position to discuss sovereignty with us because of his 35-year career representing Native American tribes. In 1984, he filed the first gaming case in Oklahoma, and after 3 years, he and his team succeeded in showing Indian gaming was a sovereign right of tribes. Since then, he has been the attorney for many tribes in Indian gaming and was general legal counsel for the Oklahoma Indian Gaming Association. As our chief, he is presently leading the negotiating team on compact negotiations with the state of Oklahoma and is representing the Osage Nation in gaming proposals in the state of Missouri. Chief Standing Bear is also leading the Osage negotiations in the battle over water against the state of Oklahoma. He seeks to reestablish unlimited use of water for the Osage. Chief Standing Bear believes the law supports his position that the Osage are entitled to unlimited use of water for the mineral estate production, Osage farming and cattle operations, restoration of the bison herds, water storage, and sale of water in Osage County to other governments and users. Chief Standing Bear has been ranked nationally in the best lawyers of America for over a decade. Chief Standing Bear, tell us about Osage sovereignty.
Well, thank you, and thank you to the Osage Cultural Academy for this chance to share with you some concepts about sovereignty. Sovereignty is a European concept which has spread throughout the world and is now recognized in international law. For the Native American tribes, we look at sovereignty through the eyes of the Supreme Court of the United States of America. One of the great resources we have in our time is Wikipedia. And in Wikipedia, I would ask you all to go look under the word sovereignty, and they will talk about some of the history of that term and its meaning as it's developed over the years. For sovereignty of the Osage, we must go to first the Supreme Court of the United States of America, and we must look at what they call Indian sovereignty. And that is where we use the word today. And Indian sovereignty is best described in a set of cases from the 1830s involving the Cherokee Nation. We call those cases the Marshall Trilogy. Please go to Wikipedia and you'll see the Marshall Trilogy, and actually I have my iPad here, and if you'll bear with me, I'm going to put on my glasses and read you what it says. The Marshall Trilogy, 1823 to 1832, is a set of 3 Supreme Court decisions affirming the legal and political standing of Indian nations. In the case of Johnson versus McIntosh, the United States Supreme Court held that private citizens could not purchase lands from Native Americans without permission of the United States. And this is where our whole concept of land, Indian land, fee to trust, and other land concepts come from. And to this day, when a tribe buys lands, like we purchased Bird Creek Farms many years ago, but 3 years ago we tried to place it in federal trust. Well, the reason for that is that even though the land was in the name of the Osage tribe or Osage Nation, it doesn't count as Indian lands unless the United States of America is involved. And they have to be involved in some official federal action. And I can announce that 2 days ago, we received federal notification that our fee to trust application was approved after 3 years. So it is now official Indian land, Osage Reservation land over there on the Bird Creek Farms. We have purchased the 43,000 acre Bluestem Ranch. We're still going through that process, and these processes are complicated, and it takes years of working with Washington, D.C., Muskogee, and our Osage Indian Agency. If an Indian an Osage Indian or any Indian owns land that's held in restricted status or trust status, like our Osage agency here, we cannot sell it without permission of the federal government. And there are many rules on how that is done. So there's that one case and an example of how that lives today. The second case in the Marshall Trilogy is called Cherokee Nation versus Georgia. In that 1831 case, Chief Justice John Marshall set forth some basic rules of our relationship with the United States and the states of the Union. Justice Marshall and the Supreme Court said that the Cherokee Nation is a dependent sovereign nation with the relationship to the United States like that of a ward to its guardian. So we have the whole concept of the Indian tribes being the ward to its guardian. And how that translates today is that we have trust relationships where we are protected, and also we have rights from before the United States was even formed that are recognized today. Because remember, the tribes, as Justice Marshall and the Supreme Court have recognized, and many courts after this, the tribes existed as political entities before the formations of states. Oklahoma was 1907. Before the formation of the United States of America, and even before the Articles of Confederation, where the colonies at that time formed an association, a federation. So Indian law recognizes this, and as the Constitution of the United States says, only the Congress of the United States can regulate commerce or trade or activities with the tribes, not the states. It's federal government to the tribes. And in that relationship, the federal government is our guardian, and they have a trust responsibility to make sure the states and those who are not tribal members or who are not tribal governments stay away from our rights. Now, what are those rights? Those are case-by-case questions. Different tribes have different rights. Today, for example, we are talking about our cross-jurisdiction relations on crime enforcement with the county, the city, the state, and the Osage Nation Police Department. We are working all the issues that go into those questions and result in contracts. So then the third case in 1832 is called Worcester versus Georgia, and it looks like Worcester, like the sauce, Worcester versus Georgia. And that is a continuation of the case of the previous year of Cherokee Nation versus Georgia. And there it says, it lays out, as I was mentioning, some of the relationships between the tribe, state, and federal government, stating that the federal government was the sole authority to deal with the Indian nations. Now, that is the Marshall Trilogy. Look it up in Wikipedia and wherever else you may want to research. And all Indian law is based on those three cases. And Indian law is nothing more than the resulting documentation that comes from the conflicts between three sovereigns: the sovereign of the native tribes, the sovereign of the United States of America, and the sovereigns of the state and its entities. And that continuing conflict results in law, and that's what we call Indian law. Now, within each, you have its own internal rules. And one point to understand about Indian sovereignty, including Osage sovereignty, is we've given up our rights to treaty with France, Spain, and other countries where we had treaty relations, and Great Britain. Actually, Osage did not have Great Britain, but we had France and Spain. And we decided by law, and we signed a treaty, only to have treaty relations with the United States of America. Like most, not all, but most tribes. In that case, that means we don't have our own army, that we have many other external relations that we have given up. But for tribes, our internal relations are where we exercise our sovereignty. And all governments have sovereignty. Okay? And that is a right that allows you to conduct your business among your own people in your own territory. So it's important to know what the territory is of that tribe you work with, because that determines where the tribe has sovereign authority. Then you must find out what is the nature of that sovereignty within that territory. And for example, a non-Indian comes in and commits a crime against another non-Indian. Federal law says the tribe does not have authority at this time to handle that. It must be referred to the state through a process that we all use. Or if there is a crime involving an Indian or a non-Indian that is a violent felony, and by the way, previously I was talking about misdemeanors. A felony, that requires the federal government and the FBI and the United States attorneys to become involved in. So so it's confusing. And we have been trying, as Osage and other tribes, to push back these other governments' incursions into our sovereign territory. Because what's happened over the years is that the states and the federal government have crept into our area, and it causes nothing but confusion. So that's a project we're all working on. Now, in my days of the Navajo Nation, I noticed that the old timers were referring to sovereignty as a rainbow. And I asked my translators, because they were speaking Navajo, all the old folks, what are they talking about? They said, well, in their tradition, sovereignty is a rainbow above their nation that protects them. And when they call for discussions of litigation or issues where the state or the feds are coming in there, they talk about someone trying to break into the rainbow. Okay? Now, when you look at the Osage, we do not have a word for sovereignty in our traditional language. So we have to understand how we want to translate this. And we have people that we have designated as qualified to work on these language issues. I can tell you, from my point of view, sovereignty means external sovereignty and internal sovereignty. And when we're talking about internal sovereignty on our territory, we're talking about taking care of our own business. And the Osage traditions on this can be summed up in a lesson that we were all taught as young people, and even young adults by the elders alive at that time. They said, be good to one another. Take care of each other. And that's really what it's about, from my point of view, about taking care of each other. Okay? Now, those of you that work at Osage Nation are going to be involved in delivering services and taking care of people. And that's what sovereignty is all about. Taking care of each other as co-workers, taking care of the people you serve, that is sovereignty within our territory. Granted, many of you will be asked to deliver services off Osage land. When you do that, let's be sure we all understand what the rules are on this. So if you're in the Indian Health Service type jurisdictions, and then you're in our health clinic, which is a tribal program, you're going to have to work with the systems we have agreed with on Indian Health Service of serving all Indians within Osage County, okay? That's off Osage tribal land, but it's serving that area. We have our Indian Child Welfare Program, which services people throughout the United States on issues involving Osage and sometimes other children. So we have to understand, when we go off our territories, what are the rules of engagement? And that protects you, make sure that we all know that we're covered by our grants, we're covered by our tribal funds, we're covered by our insurance, and that everybody's on the same page. So within our territory, we have pretty solid understanding. And when we go outside, we usually have a pretty solid understanding. We have good directors that are trained in these areas. Don't be afraid to ask questions. And in fact, you need to ask questions if you don't understand. So welcome to the Osage. We will support you completely, and you are exercising Osage sovereignty. Thank you.